And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I remind everybody, hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. And the StreamYard link is down there for anybody who wants to join the panel. It is an open panel for anybody. And we are going over the accommodation party and that unambiguous signature. So, the premise here, and I just spoke to a friend of mine about the forms and everything that everybody thinks they need to fill out. And just a topical part of it here is that you do not need to fill out any of those forms so long as you provide all the information that they are requesting on a form. You can put it in your own handwriting in your own document with your own expressions otherwise that are not stated on the form in order to clarify things more succinctly. So before we get into the accommodation party and unambiguous signature, we're going to review a quick little video on Facebook from a Joe Lustica. Now, if you're not familiar with Joe, I suggest you follow him. He's on TikTok, Facebook, YouTube, and all that. You can find him by his name. We're going to take a quick look. Let me change my screen here. Make sure I got everything. Okay. And let's go. We are with Joe Lustica, and I'll put the comment in the chat real quick. And Joseph Lustica. JOSEPHLUSTICA. Joseph Lustica, like I said, TikTok, Facebook, YouTube. Go check him out. This is from Facebook, and he put it on TikTok, and they removed it. And we're going to listen to him real quick. Like I said, the forms do not have to be followed. And in this particular situation, we have people that are looking for a resignation form, resignation of agent or something like that, as it speaks of in the federal code. But that shows that they're not reading, which is one of the things that I point out, is that evidently you either don't know how to read English or you don't read English because of your laziness or something like that. You don't do your research, and you keep listening to other people and implying things because you really don't know, because again, you refuse to do your research. But when you do the research and you actually understand English and can read that English, you find out certain things. So let's pay attention to Joe Lustica here.
There is no form. Okay. I've been saying this for years. I'm going to continue saying this. There are no forms. Period. There is not one form in existence for revocation of election. The Code of Federal Regulations that talks about the termination or the revocation of election.
So there's a code in the federal regulations that does speak about the resignation of election. And when you read it, it doesn't tell you to fill out a form. Listen to Joe as he explains it. In plain English, they tell you.
Clearly tells you that it is a statement, not a form.
A statement, not a form. So when you have people looking for forms, and like I've said for many years, I don't want to fill out their forms. I'd rather make my statement because their forms are limited and very presumptive, and certainly provide for deception, known as certain deceptive forms.
The Code of Federal Regulations lay out how these agencies perform the tasks. They tell you in there if you use a form and what form to use. Inside the Code of Federal Regulations, in fact, I'm just going to show you guys. Okay, so this is 26 CFR 1.6013-6, election to treat non-resident alien individual as resident of the United States. Okay.
Election to treat non-resident alien individual as resident of the United States. The 14th Amendment, where they consider you a resident. As we talked about with the Accommodation Party, it is for the federal travel program, and it is for expense allowances for residents.
Okay, and in here it tells you how to do the election, but also in here it tells you how to do the revocation of the election, right? The termination. Here, I passed it. Termination of election, revocation, right? It says right here, revocation of election is made by filing a statement of revocation of the following matter. If the spouse revoking the election is required to file a return. Okay, anyway, but there you go. It tells you it's a statement.
Election to file a return. So in here it's talking about the IRS, Internal Revenue Service, the taxation. And like I said, everything that we do in this commercial system is dependent upon two things first and foremost before contracts can move forward. And that is the assessment for tax purposes and, of course, an insurance.
It is not a form. All right, I want to make this abundantly clear to people. When someone tells you to use a form to do a revocation of election, they are misleading you, or they themselves have been misled and now sharing bad information. I'm not interested in sharing BS, bad information. I'm interested in showing people the truth. That's it. Okay? Show people.
That's it. That's it, folks. That's all I'm here for. I'm here to show you the truth and explain it the best I can. But understand, I can explain it to you, but I cannot comprehend it for you. If you think statement means that you have to find a form to fill out so you can make that statement, then you're the one that is not comprehending because it's in plain writing. So, here's a good one. Dean puts down Washington State wanted an application to get a waiver to pay them back. A waiver to pay them back. Why would you need, what is it you got to waive in order to be able to pay them back? And if you don't get that waiver, can they make you pay them back? See how ridiculous this sounds? So greetings, everybody. Oh, waiver to not pay them back. Okay, up here you said a waiver to pay them back and a waiver to not pay them back. Either way, if you need a waiver to not pay them back, then that's what we're talking about here. Is there's something in there that says that they are classifying you as one that does, in fact, have a requirement to pay. Okay? I want to greet everybody. Thank everybody for joining. Please hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to help with any kind of love. All is appreciated. And of course, the StreamYard link is down there for anybody that wants to join the panel. We're going to be here for a little bit talking about the accommodation party and that unambiguous signature, how to clarify it so it's not ambiguous. In other words, when you put just a regular signature and you don't clarify anything, then it becomes, it's known as an ambiguous signature, which they call in their system a blank endorsement. So let's take a look. Again, at 41 CFR 302-11.106, what is an accommodation party? And like I said, that residence through the state ID or driver's license is the beginning of that public contract as we turn into young adults. We become the age of majority. We get that high school diploma. And rather than accordingly acting as a diplomatic detail, which is because we weren't really taught diplomacy, even though they call it a high school diploma. Diplomacy is about etiquette in your communication and knowing how to address each other. Sir, ma'am, madam, sergeant, lieutenant, corporal, Mr., Mrs. I don't have any of those titles. Don't call me Mr. Little. I'm not in the military. I don't have any military rank. You want to call me anything, call me Brother Keith. Or as you'll see me sign off on any of my communications anymore, reverently, ;stop, Chaplain Keith, ;stop, Chaplain Keith. Brother Keith, Chaplain Keith, I love him. That's what I prefer to be addressed as. So here we see Title 41. It says public contracts and property management. Management. The mentality of being the age of a man, the age of majority. When you turn into young adults and go out and get that state ID or the driver's license and get involved in public contracting, even though you're not a public official or an agent. That itself is the contract, the public contract, that does make you an agent because you give them an address as a resident. And you say, I'm a United States citizen on that application. Allowing them to use that election to go ahead and tax you. You're the one that makes a statement because you don't do your research to know. I didn't do it either. I didn't know. I was a bitch-ass slave. I was a fucking fool. It's time to understand what's really going on. Do your research so you know, so you can help your children, your younger generations. Again, I was that bitch-ass slave because I didn't do my research. So don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud. Don't believe your mom and dads. Do your research so you know. Because once you turn age of majority and start traveling out upon the world, that ID says you're in the federal travel regulation system. So again, you have the right to travel. Of course, you have a privilege to travel under that ID. It's a state-granted privilege to travel. Wherein the scripture says, the land shall not be sold forever, for ye are strangers and sojourners with me. And as we go across that land, God damn it, my apologies, folks. So now you can see, we're talking about public contracts and property management, federal travel regulation system. And as that scripture says, the land shall not be sold forever, for ye are strangers and sojourners with me. You are not identified. You are not domestic. You are strangers. And you are not residents wherein you dwell in one place. You're constantly sojourning out and about in your community or even beyond. The Lord shall preserve my going out and coming in from this time forth and even forevermore. What says that I need a travel document then? Again, relocation allowances. So it's allowances to move. Residence transaction allowances. Allowances for expenses incurred in connection with residence transactions. So we're talking about those commercial transactions that have a legality of them based on residency. What is an accommodation party? And it very simply says, in one sentence, it tells you everything you should need to know as to what that name is. An accommodation party is an individual who signs an employee's financing agreement. Now, I remind you, when you started that public contract as a resident through the state, you become presumptively and on record, as the record will reflect, that presumption that you are in fact a state employee. An accommodation party is an individual who signs an employee's financing agreement, a mortgage, to lend that individual's name, That is the loan, folks. And in that loan, it says, i.e., credit. Credit to the arrangement. So no matter what arrangement you have, where you make an agreement with somebody else across a counter, and you give them that name, that is a lending of the name, because they wouldn't have it unless you gave it to them. Understand? So, when the nice policy enforcers surround me, 2 police officers, 2 special detectives, 2 FBI agents, and 2 domestic care service workers looking for 2 adults and their 3 little girls on a manhunt because they want to raise their children without the officious intermeddling of a state. And they try to get me for harboring fugitives. And they want that name. They pull me over on my bike, say, can you pull over here? Well, I guess I'm going to have to, because I can't outrun you on a bike unless I try to go through some of these yards. And I imagine there's already plenty of you surrounding me already. I'm not stupid. And sure enough, there they come. Not only do they have me surrounded, but they've got my woman over at her place, scared shitless, demanding of her the same kind of things when they have no business doing so. See, they have to prove that you're actually committing a crime before they can commit a crime against you and violate your rights during their investigation. Just because they have an investigation doesn't mean they just blatantly get to go around violating people's rights. So anyway, when they pull me over 8 deep and ask me for the ID, and I tell them I don't have one. Oh, wait a minute. Actually, I do. You might like it. It's just as valid as your state ID. And I pull out a homemade ID, bicycle driver's license, expires when the wheels fall off, that kind of shit. And they chuckle and say, okay, we understand. What's your name? Well, I don't have a name. Well, everybody's got a name. No, I'm telling you, I don't have a name. My mom and dad have called me Keith all my life. Now, if you can find that name on me and prove that I actually own it and possess it, then I would have to admit that I have a name, but I don't. So anyway, mom and dad have been calling me Keith all my life. Now, if they got mad at me, they might call me Keith Orland. And if they got really mad at me, they might call me Keith Orland Little. Because, see, I hail from the family Little. And I hear I was born around August 20th, 1966. And so when they're looking for the name, the first and last name, and the birth date, I didn't give them no such information. I did not give them a first name and last name. I did not give them a birth date. If they write it down as such, that would be their miscomprehension, because they obviously don't understand English and can't even hear it right. That's how important the details of information is. So that when you get these forms and they ask you for a first and last name, that's the legal name. If they're wanting to get you up involved in legalities for their commercial transactions because you claimed you were a resident. Your fault, in part, not wholly, but still, you are partially at fault, and you have to find out why you're at fault, understand why you're at fault, and be man or woman enough in your adultness to do your research so you can correct it and no longer do that anymore. Repent. Quit sinning. You are lying. You are babbling if you don't know otherwise. So let's get back into it. The next one we're looking at is 12 U.S. Code, Subchapter 8, Armed Services, Housing, Mortgage, Insurance. Again, like I said, if you folks don't understand this and don't believe it, that's fine. I'm telling you not to believe it. I hope one day you will understand it. You will comprehend it. Again, I can explain it to you, but I cannot comprehend it for you. You must do your research. And I am telling you that this is all a military government. 5 U.S.C. 301, minimum birth registration standards. So the birth registration under departmental regulations, which is a military department applicable to the Department of Defense. If you don't understand it, you'll have to do your research, because that's the best I can explain it. And so when you're filling out these applications as a tenant in lieu of the landlord, that's the lieutenant that you're being errantly addressed as, because you're a tenant and don't understand that you're a tenant in lieu of the landlord, and that it's all military as a matter of relocation. Why do you think they want to do a credit background check if you move into an apartment or a house? They want to check where you've lived before. They want to make sure that you're relocating from within the domestic zones. Mortgage means a first mortgage on real estate in fee simple or on a leasehold. Term personnel shall include military and civilian personnel approved by the Secretary of Defense or his designee and the dependents. and the dependents of all such personnel. If the military is providing the military defense and you are just a lowly peasant that doesn't even have a home, you've never been in the military, you've never had a job, you're homeless, are you dependent upon that military protection? Or can you stand up for yourself? On domestic soil, of course. See, if there's no war, are you really a military dependent? Even in times of peace, there is a presumption that you may be a military dependent, because if war ever comes to your shores, you will then need to depend upon the military. So even when you're in times of peace, you are still presumably dependents, as that term goes. And as you can see, it is not clarified any further. Term military includes Army, Navy, Marine Corps, Air Force, and Coast Guard. What about the civilian? How come civilian isn't defined? Anybody find definition of civilian for me? Now the next one is an interesting one that I've spoke about before. And greetings, John. How you doing today, brother?
Good, Brother Keith. Yeah, I could get the let's see, the definition of civilian if you want it from Blacks. Well, I don't have it up yet, but so go ahead.
Well, yeah. If they're going to show civilian in Black's law, that's fine. But I'm looking specifically for in the U.S. Code as they define it, and not some judge on a bench that gave his opinion. We're talking about absolute definitions here according to them.
Oh, okay. Yeah, I think it says private citizen in the Blacks, but I got it though. Yeah.
Yeah, and see that's what it is. In fact, if you look it up under like a Webster's dictionary or something, they'll tell you it's a private citizen. But again, what is that citizen if they're saying they're a resident of the state? That private citizen then would be a private citizen of the state. And because he's got an ID in his pocket, he's actually on call 24/7. Because if they come knocking at your door at 3 o'clock in the morning with a warrant, you damn well better answer. Otherwise, they're going to break it down. They're still going to just drag you out.
Yeah. Plus, we now have a trade war. See, we're always at war, Keith.
Absolutely. That's the program of economic warfare that I discussed here a while back in the Cambridge University Press article, The Secret Life of Statutes, a Century of the Trading with the Enemy Act. And it tells us in there that the United States is known, in fact, and considered the New World Order, and that this program of economic warfare is expanded beyond the fields of war and on the domestic soil during times of peace against its own people. That's why you have the identification. They're saying that without that identification, you might possibly be an enemy. So therefore, they have to check your identification to make sure you're not an enemy. Really? Shouldn't you be doing that at the borders and not on my home soil where I was actually born and have never left? Again, stranger and sojourner with him. Go ahead, John.
It could be why we're always at war, because it justifies the POWs that are here, which are us, or at least we're attached to one. You know.
Yeah, yeah. And a lot of us presume to be those dependents or residents or civilians. Those are military terms for people that are captive, whether they know it or not, and whether they're voluntarily staying behind with their other fellow patriots that are held captives. Read the Lieber Code. You'll find out what this is all about. Again, I'm telling you, it's military governance. This here says, and this is Foreign Trade and Commerce, 15 U.S. Code, Foreign Trade and Commerce, 1605, determination of finance charge. Remember, it's a war. Da 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 da. Charge. That's what we're really talking about, folks. Without the military, you would be able to do your hand to hand, not combat, but hand to hand arbitrations. In other words, I get to agree with my neighbor without some other motherfucker sticking his nose in my business. Finance charge defined, except as otherwise provided in this section. The amount of the finance charge in connection with any consumer credit transaction shall be determined as the sum of all charges. So when you go to the automobile dealership and you see a finance charge of $100, any consumer credit transaction, that shall be determined as the sum of all charges. Yet they have you signing documents and believing that you now have to pay an installment plan. If you already paid the finance charge, which is the sum of all charges, then what are we doing paying monthly bills? And I want everybody to understand, you might not think I don't know what I'm talking about. And I urge you, don't believe me. But I'm going to tell you of a recent success. This last Saturday got news. You know, I run a Saturday morning equity class. Started out with me and two gals that came to me asking me to teach them about equity. We now have 30 people in the class. We meet every Saturday morning. And she came back this last Saturday after an arbitration that took a matter of almost 3 years in regards to the purchase of a car where they stated the finance charge. She paid the finance charge, and as I stated, we went through arbitration for a couple years there, and she won. So she's just waiting for them to deliver the car that she's been telling them they need to deliver for a number of years, because she paid the finance charge like it says and is required, and says shall be determined as the sum of all charges. And then it says, this is the important part as it relates to the accommodation party, payable directly or indirectly by the person to whom the credit is extended. So when I give them the name, that's a lending of the name, and I am paying for the person named in the instrument. To whom the credit is extended. So I'm extending my credit to my person so that he can pay directly or indirectly. And then it says, and imposed directly or indirectly by the creditor as an incident to the extension of credit. So if I don't have to pay, as it says, because it's a finance charge, so I give them the name and my finance charge. So my finance charge is the only thing I pay, $100 generally. Go to a dealership and ask them what their finance charge is. And then as a incident to the extension of credit, I am telling you that the person to whom the credit is extended is the liable party, and he's named in the instrument. Wherefore I signed on the instrument. And this is where the unambiguous part comes in, where you have to learn to stop paying or signing in blank. How many times have you signed in blank, John?
Many.
And why did you do so?
Didn't know any better.
Absolutely. Why? Because nobody in school taught us that there should be something else going with our signature. That if we don't put something else with our signature, it is considered a blank endorsement and somebody else can use it to their benefit and our detriment. Now, if I had one of my teachers that knew that, you would expect that they'd teach me. If I had one parent out of all of those parents that I had in all the foster care systems and the parents that adopted me that knew that, you would think they might teach me. See, this is the thing about that feed a man a fish, you feed him for a day. Teach him to fish, you feed him for a lifetime. If you don't teach your own children and you feel you've been indoctrinated and are starving for that fish, you are putting your children in the same position. That's part of the problem is my people are destroyed for lack of knowledge because nobody's really educating others on the necessities. They're teaching them basics like reading, writing, and arithmetic. But does it really go beyond that? Not much. Goes on to say the finance charge does not include charges of a type payable in a comparable cash transaction. Finance charge does not include charges of a type payable in a comparable cash transaction. The finance charge shall not include fees and amounts imposed by third-party closing agents. So when you're at the dealership and they're going to use the bank as a third-party closing agent, the finance charge shall not include fees and amounts imposed by third-party closing agents. So if that dealership is passing on those charges to you, then that's an addition to the finance charge, which was the sum of all charges. And that, in fact, is a violation. They are the ones liable for those charges because they are the ones that hired the third-party closing agents. Okay? Including settlement agents, attorneys, and escrow and title companies. See, if you're making a private purchase, that title should go to you. And you should be using a third-party financing agent, closing agent. You know, like a Fidelity account or Chase Morgan account. You know, those bond investors where you can take your paperwork to them, say, okay, I'm the accommodation party. Here you go. Make sure the finance charge is taken care of. All this is the sum of all charges. And they will do it. That's your property. And you can place that on deposit with the right person where the correct double entry ledgering will be done. If the creditor does not require the imposition of the charges or the services provided and does not retain the charges. How do you retain the charges? By making sure that you require the imposition of the charges. The finance charge shall not include fees and amounts imposed by third-party closing agents if the creditor does not require the imposition of the charges or the services provided and does not retain the charges. So simply letting them know that you're the accommodation party by making it unambiguous by accommodation party should be enough. And that's all we did. And then they wanted to argue that says and saying, no, that's not how it works. Because they didn't read this and understand it. They didn't comprehend it if they did read it. because this is very succinct. It's telling you, you are the one that puts the imposition and imposed directly or indirectly by the creditor. If you're the one lending the name, then you are the one that is called the creditor, because the name is in fact the credit. The name is in fact the credit. Everybody wants to know where the credit comes from. It's coming from the name. Okay? So let's take a look at this. This is just a regular chat GPT, and I put in what is an accommodation party according to U.S. law. And it says an accommodation party in U.S. law refers to a person who signs a negotiable instrument, like a promissory note or a check, or a purchase order, as a guarantor or surety for another party's debt. Okay? For another party's debt. So you impose the extension of credit to the person, your person, extending the credit to it, because it's the record. And you're going to allow the record to make the payment now, because you paid the finance charge. $100, whatever that finance charge is, it is the sum of all charges. And you have to stick to your guns on it, because these people will tell you, well, that's just not the way it works. We ain't never done it that way. Oh, imagine that. You've never done it that way, so you've never followed the law. Your ledgering is not done according to the general accepted accounting principles. Is that what you're telling me? That double entry ledgering is not complete? Is that what you're telling me? You're telling me you're not completing the double entry ledgering? That's because nobody's signing in the proper capacity. And so when somebody does and makes it unambiguous, they still sit there and say, that doesn't matter. That's not the way it works. It is the way it works. I guarantee. Without receiving any direct benefit from the transaction. Well, that means you're not the beneficiary. No, I'm not the beneficiary. The person is the beneficiary. The person is the beneficiary as a debtor who allows me to impose the credit to him so it can be paid, and that's its benefit. Okay? But as the benefactor, the one that gives to the beneficiary, I have the right and interest in the transaction of the the enjoyment of the possession and use of a thing for my benefit. And I'm not purchasing it for somebody else's benefit. I'm purchasing it for the family so that we may use it. The accommodation party essentially helps another person, the accommodated party, by guaranteeing the payment of a debt in the case the accommodated party defaults. When they send you those third-party debt collections and threaten to sue you in court, and they're saying that the accommodated party is in default, it's only because you haven't expressed that you are the one that, in fact, lent the name to the first party, and they didn't do the ledgering right. So and of course, it's because you don't know either. So when you do know it, you can correct all those third-party debt collectors and keep them from coming in and taking all the money out of your account, because there was a finance charge and you did lend them the name according to the law, because without you giving them the name, none of the paperwork in that particular series of transactions would be valid, because it don't start without a name. They can't just go around putting your name on it. Only you can do that. but the accommodation party does not stand to gain financially from the arrangement. Why? Because all I'm doing is extending credit. All glory goes to him. That's where I get my credence. And a man is bound by his words. Key points about an accommodation party, and stop me anytime you feel it. And I want to take a minute to thank everybody and remind everybody hit that like, share, and subscribe button. There's a PayPal link down there for anybody who wants to share any love. Every little bit is appreciated. And of course, the StreamYard link is down there for anybody that wants to join the panel. Go ahead, brother.
So, are we like a release agent, or are we just signing unconditional promises?
Depends, again, who you're dealing with and how they're treating it on the other side of the counter. In effect, any kind of blank endorsement in any kind of transaction is just like a blank endorsement on a check. What you're doing is you're handing it over to somebody else to allow them to secure it.
Okay.
And when they secure it, they're going to secure it in their name. We got Bear Jew, Dean Phillips, Barbara, let's see, Captain Action, Dr. D-Head, The Tribe, Facts in the Industry. Welcome, everybody. Yes, every word counts. That is what is accountable. Tori. Is Tori still around? El Perro. Tori, yes, from Facebook. She's around, but I think she's gone a little bit more private. Still around. You can get a hold of her. I will look it up. Get a hold of me on Facebook. So let's get back to it. Key points about accommodation party. As somebody else mentioned, guarantor or surety. Yes. The accommodation party is acting as a guarantor, promising to pay the debt if the accommodated party cannot. Again, that election saying that it's a resident United States citizen, meaning it's a business. Do you really own a business? Or was there a business granted to you on behalf of the United States, a bankrupt entity, allowing you to operate a franchise so that you can make a profit for them? How can you make a profit for a bankrupt company? They have to settle all their debts first. So any money that you're making for that company is going to pay off debts, not as a profit that will come back to you. No direct benefit. The accommodation party does not receive any consideration or direct benefit from the agreement. Okay? It's one of those important elements of understanding the gifting, the family, and the individual name. I'm not getting it for myself. I'm getting it as a matter of family affairs, a necessity of life, so that I can be that stranger and sojourner with our Father in heaven, and that if I'm not around, the family may continue in that sojourn. It's not directly for my benefit. It is, in fact, for the benefit of my wife and children. So indirectly, I may benefit, but it is not a direct benefit. So I don't go buy a car for myself. I go buy a car for my companion. So I put her name in there. Now, the gal that I'm talking about, she didn't put anybody else's name in there. I'll have to get the full detail. I think she put a trust name in there. Her name, Estate Trust. That's the name of another person. That person didn't have any financial records at the time. It couldn't pay a debt. It wasn't qualified. So she extended credit to it. And again, if you understand the language and you can deal with it, you will go through the arbitration. $78,000 vehicle for $100, the finance fee, and then two plus years of arbitration. Liability. This is where the unambiguous part comes about. And we'll be talking about that next as it relates to the signature. Liability. The accommodation party is liable for the debt in the same way as the primary party, the accommodated party, but typically only if the primary party defaults. So if the primary party is a fictional person, it is already automatically in default. It cannot pay anything. It is the person named in the instrument. It cannot travel outside of the instrument. It cannot actually do anything. It is a fiction. So you must do for them or for it. Then it goes on to talk about common and negotiable instruments. Accommodation parties are often involved in negotiable instruments such as promissory notes or checks, where the signature supports the creditworthiness of the primary party. In short, an accommodation party is someone who lends their credit to assist another party without personally benefiting from the transaction. What do you think so far, John? Is this making sense? Is it clear to you?
Looks more like obligations than contracts to me.
Absolutely. That's what those negotiable instruments are. And if you know your place in it, goodness gracious, if there's a third party involved in a contract with me and another man, and we both pay a finance charge, then we're both clear. We're both showing that we are extending credit to the persons named in the instrument. That's the imposition. We are no longer in the position of debtor because we have imposed the debt onto the person in the instrument because we extended credit to them because we know they can't pay. Does that not make them the debtor?
It would.
Like I've said many times, in all transactions, you have two creditors and two debtors at minimum. And that is at least the two people that are contracting together. Whether there's a third party intermeddler or intervener or whatever you want to call them. Because while you're extending credit, you are indebted to them because they are extending their credit and therefore they are indebted to you. This is the thing about recognizing the credit, understanding how these contracts work. Say, okay, well, as long as I make it to my neighbor's house with this dozen eggs as I promised him and don't break any, I'm going to fulfill that contract and I'll pick up that loaf of bread in exchange. Guess what? The contract doesn't even need to be written down, but a man is bound by his word. So if he's traveling over to his neighbor's and he's got that baker's dozen eggs like he promised, there's 13, and he drops when he breaks 5 of them, does he go on and give him the other 8 and say, there you go? No, he's still got at least retrieve the other 4 to make it the actual dozen, or the 13 if he promised the baker's dozen. So he could go over and then negotiate with his neighbors. Hey, man, I just walked a mile over here and I accidentally dropped the eggs and I broke 5 of them. Now, when I come back over tomorrow, I'll bring the other 5 eggs if I can have that loaf of bread today because we don't have anything in the cupboard. See, the neighbor's probably going to work it out, even though the contract is still in play and there's still some kind of debt in there. It doesn't necessarily need to be written down, but that's the way this system poses it, that you must write it down so that they can keep track of the debts to make sure that you are dealing with your neighbor fairly. None of your business. I can handle it myself. Okay? So let's take a look at the next one, which is UCC 3-419, instrument signed for accommodation. Okay, and I remind people of UCC 3-402 as it goes to negotiable instruments. The authorized representative giving an unambiguous signature on the instrument is therefore not liable for the person named in the instrument. And so when you sign blank, you're giving it an ambiguity. You're not signing as an unambiguous signature, but you're giving an ambiguous signature where they don't know what you mean. They don't know whether you're a state actor or if you're the accommodation party extending credit or this or that. So there remains a liability. And so when they have a question, say, well, that's not how it works, they're going to go to you because you're the one that signed the document. This is where your liability lies, folks, is the information, the knowledge. So that you can tell them, oh, I'm sorry, my mistake. I forgot to put down by accommodation party. Let's rework this contract because that was not my intent. That was an accident that placed a liability on the public record where it shouldn't be. Because the proper signature with the proper finance charge in the proper contract is a release of liabilities where that follows the indemnification clause that should be in that contract. So let's read it. If an instrument is issued for value given for the benefit of a party to the instrument, and it says here accommodated party. So if the value is given, the credit is given to the person named in the instrument, the accommodated party, and another party to the instrument, the accommodation party, signs the instrument for the purpose of incurring liability on the instrument without being a direct beneficiary of the value given for the instrument is signed by the accommodation party for accommodation. Simple. Tells you right there in quotes. And just like we started this stream out, that federal code for resignation of election doesn't tell you that there's a form to fill out. It tells you to make a statement. So when 3-402 tells you that there's no liability if you sign on the instrument, there's no liability for you. It's because you have to give an unambiguous signature. The unambiguous is making sure that it's plain and clear for accommodation. For accommodation by authorized representative for accommodation. An accommodation party may sign the instrument as maker, drawer, acceptor, or endorser, and, subject to subsection D, is obliged to pay the instrument in capacity in which the accommodation party signs. By authorized representative for accommodation. The obligation of accommodation party may be enforced notwithstanding any statute of frauds and whether or not the accommodation party receives consideration for the accommodation. See, that's where your benefit comes, is the indirect consideration. The indirect consideration or the indirect benefit is that consideration wherein it is considered that if I'm buying that car for my wife or for family use, then I get to use it. My rights and interest, property as defined, my rights and interest in the enjoyment of the possession and use of that automobile for my benefit. Because I signed for accommodation, paying another person's debt. I paid for the other person. A person signing an instrument is presumed See, this is where they get it all wrong. They say, well, that's not the way it's done. We've been doing it this way all along. We've always done it this way. Because you don't know what the fuck you're doing. Because again, right here, a person signing an instrument is presumed to be an accommodation party. And there is no notice that the instrument is signed for accommodation if the signature is an anomalous endorsement or is accompanied by words indicating that the signer is acting as surety or guarantor with respect to the obligation of another party to the instrument. So a person signing an instrument is presumed to be an accommodation party.
Well, it's a train wreck, Keith, because shouldn't contracts include arbitration and indemnification clauses?
Those are the two basic elements of contracts that are implied. They're implied.
Oh, okay. Right.
Just like this here, it's implied. That's the presumption. It's an implication. It's implied. Okay? So as a presumption to be an accommodation party, but the signature says that it's supposed to be unambiguous so that you can make that clear. But even if it's not clear, these people running these instruments should know that it's presumed that you are the accommodation party and you are to be accommodated in the proper capacity as the one that gave them credence to do all the paperwork for which then they get paid. See, I'm not getting paid. I have a consideration to receive, but I am not getting paid. You are getting paid to do this, and according to your pay, you're supposed to make sure that the record is holds integrity. If you're going to sit there and put false implications down and say that's not the way it works, I beg to differ. Indicating that the signer is acting as a surety or guarantor. Yes, I'm acting as the surety or guarantor. I guarantee you you're wrong. I guarantee you I am the source of credit. You dumb third-party debt collectors have been doing this all along. You dumb financial supervisor down to the local courthouse, allowing third-party debt collections to be entered into those courts, and then just taking money out of people's bank accounts because a court ordered it, knowing that the signer of the instrument is in fact the accommodation party, the one that gave credit. And yet somebody else is saying that somehow I owe them a debt. How am I the one that owes a debt if I'm the one that extended the credit? There's an exception. Except as provided in Section 3-605, the obligation of accommodation party to pay the instrument is not affected by the fact that the person enforcing the obligation had notice when the instrument was taken by that person that the accommodation party signed the instrument for accommodation. The obligation of an accommodation party to pay the instrument is not affected by the fact the person enforcing the obligation had notice. My obligation stands, and under my obligation, I am telling you, I lent you the name, that is the extension of the credit, so my obligation is to tell you if you don't understand. And this is why I say, folks, I can explain it to you, but I cannot comprehend it for you. I'm not in arbitration with you. But if I go to somebody and I want to purchase a car, then I'm obligated to be involved in that arbitration as much as possible to get everybody involved to understand that when I signed, that was me lending credit to the arrangement. I lent my credit. I'm telling you, folks, when you understand it, when you comprehend it properly, it is prepaid. It's already known. So let's look at the next one. If the signature of a party to an instrument is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than payment. What's the difference? That the party is guaranteeing collection rather than payment of the obligation of another party to the instrument. The signer is obliged to pay the amount due on the instrument to the person entitled to enforce the instrument only if one, execution of judgment against the other party has been returned unsatisfied. So the third party debt collector has no enforcement. It has not been returned unsatisfied. It was satisfied when the first creditor charged it off with the Internal Revenue Service. And again, understand, they charged it off because you quit making payments after you already financed it. That's where they dupe you. You already financed it. You already gave credit and paid the initial, what do they call that, premium? This is what I was talking about with the insurance, life insurance. They want you to pay a premium every month. Really? That's
finance means settlement, right, Keith?
Well, yeah, it's you're the one that's paying for everything. And again, I'm telling you, the payment is a matter of the right words. It's not a matter of the fiat currency. It's not a matter of the form you fill out. It's not that money order. It's not the check. It's the words. Two, the other party is insolvent or in an insolvency proceeding. Is that a United States business involved in insolvency? I mean, it is insolvent, correct? I mean, they actually have no real property that they can claim as theirs, except through a private contract with somebody else who then takes on that liability of debt. 3, the other party cannot be served with process. See, that's that address. That's that residence. See, that's that diplomatic channel of notice. I was talking the other day on a friend's panel. When you get that person, that birth certificate, again, this is according to my research, my opinion is that we're supposed to hand that off to the United States for full reconciliation of all financial records so that all parties may be made whole and no person shall be held liable in any court. And that's where you file the personal jurisdiction into the United States courts so that they have personal jurisdiction. Now, when the state claims that they want to file a complaint on you, they have to use the diplomatic channels of notice and go through the United States because they're the ones that have the person, not you, nor the state. So if the state comes out and says, well, we're going to charge you, I'm sorry, but you failed due process. You failed to notice the United States as to a foreign relation and charging a foreigner in one of their courts. You're still deeming me as a resident, and you still sit there and say, well, you are, because you don't comprehend the term and how it's used. Just because I was born here doesn't mean I'm a resident of the state. Just because I was born here doesn't mean I'm a United States citizen. You do not birth, or a corporation is not born. It is created. You cannot be born in the United States. The United States is a corporation. It is a creation of fiction known as documentation. And you cannot be born in the United States. No way in hell. Ask any English major how that works. 4. It is otherwise apparent that payment cannot be obtained from the other party. So once you extend credit to the person named in the instrument, and it becomes clear that they cannot collect payment, they cannot obtain payment from that person because it's a mere record. The individual's name and number identify the record. The individual's name and social security number identify the social security record. Individual's name and birth date identify the birth record. Individual's name and address identifies the residential record. If there is no residential record, it is otherwise apparent that payment cannot be obtained from the other party because you can't find him, except in the documentation provided by the accommodation party. E, if the signature of a party to an instrument is accompanied by words indicating that the party guarantees payment, or the signer signs the instrument as an accommodation party in some other manner that does not unambiguously indicate an intention to guarantee collection rather than payment, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument in the same circumstances as the accommodated party would be obliged. So if I extend credit to the person named in the record, and somebody has to enforce it, and they go to that accommodated party, and they enforce it against the accommodated party, they transfer credits. Therefore, payment and collection is made. It's an electronic record. And all they have to do is transfer a number from this database to this database, and lo and behold, the database that receives it now has instructions that it can write up a check to have deposited in an account. Interesting how it works, folks. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party and is entitled to enforce the instrument against the accommodated party. Again, if the accommodated party is the person named in the instrument, and you are giving an unambiguous signature as the authorized representative on the instrument, you therefore are not liable for the person named in the instrument, should tell you that the person named in the instrument is the liable party. Just like it says here. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party and is entitled to enforce the instrument against the accommodated party. So when you go to the arbitration, you're not enforcing it against somebody else. You're enforcing it against the record to which you signed, saying that you understand that as the accommodation party, you signed transferring the credits to the accommodated party, and therefore those credits need to be released to whoever is demanding collection. You don't get it from me by demanding a different type of money. You get it by collecting the credit as payment. Does that make sense, John?
Yeah, we should start acting more like, I mean, more than an emergency contact person, which is pretty much all we were doing.
Correct. We're just the one to contact in case the party in the instrument doesn't pay. Now we have to pay. And I'm telling you, payment is in words, not numbers, in words. And that is your arbitration, your ability to comprehend the words before you and line item veto anything that doesn't fit so you can correct them as to the capacity of the accommodated party and the accommodation made to them. Well, we've been doing it like this all the time. Oh, so you've been dumb all this time. And I'm telling you, folks, I used to be a bitch ass slave too. I used to be a fucking fool. I used to be a dumb fucking idiot too. Eat it up. Swallow it. And it doesn't matter. It doesn't taste good. Get on, shit that shit out, and learn and grow from it. I want to take a minute to remind everybody, please hit that like, share, and subscribe button. There's a PayPal link down there for anybody who wants to share some love if you find any kind of value in this. Every little bit helps. Every little bit is appreciated. But again, the more you learn this stuff, the more you'll be able to affect your own finances and understand how things are prepaid. And again, you'll have to deal with arbitration. That means you have to learn how to communicate with others. And the payment is done in the words. You have to understand the words. You have to learn how to comprehend them. I'm urging everybody, unlearn the things you've learned and relearn concise English. Start all over and go back to the beginning. Do some etymology. Understand what these words started out as in the origin and how they've transformed over their uses in different cultures and languages. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party and is entitled to enforce the instrument against the accommodated party. So all of these years, all of those documents that you signed your name on, and all of the charges that have gone through that system, you're the one that gave them. And those credits still sit in the system. If you've been paying those bills with cash and checks and stuff, the credits still sit there on the other side of the ledger and is entitled to enforce the instrument against the accommodation party and is entitled to reimbursement from the accommodated party. What he puts out is to be returned. If you, in fact, were held to a debt, wherein that scripture says, "Oh, no man anything but to love one another, for to love one another is to fulfill the law." And if you love somebody enough that you want to teach them how to fish so that their life isn't destroyed. In proper circumstances, an accommodation party may obtain relief that requires the accommodated party to perform its obligation on the instrument, the double entry ledgering. The accommodated party is the one that holds that ledger, and they must do the ledgering correctly. They must do the double entry and correct the credit side, and that is a reimbursement, a reparations, as you might call. All those taxes you paid in, despite the fact that you were the one that gave credit to that person. And then they started charging that person and then said, you owe it. And you paid in the wrong way. Now you can be reimbursed. Again, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mom and dad, especially if they're still fucking paying taxes. Do your research so you know. An accommodated party that pays the instrument has no right of recourse against. An accommodated party that pays the instrument has no right of recourse against and is not entitled to contribution from an accommodated party. Why? Because you can't claim that the creditor is the one that owes the debt. Does that make sense?
Yep.
Makes sense to me. I mean, it's plain writing. And again, I urge you people, unlearn and relearn the concise English you should have learned so that you can start reading this stuff and comprehend it yourself. I can explain it to you, but I cannot comprehend it for you. You can ask me to do the paperwork for you, but I won't. I won't. That's a death trap for you and a jail sentence for me. It's dangerous. And I don't do it. The next one. 15 U.S.C. 15 U.S.C. 4724. Excuse me, I'm wrong. 1602. I'm thinking a different one. 15 U.S. Code 1602, definitions and rules of construction. Okay. We down here to credit card. The term credit card means any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. Anything you signed, any application, registration, or otherwise that you signed to obtain money, property, labor, or services was a device to obtain money, property, labor, or services on credit because the name itself is the lending of credence to the instrument. Does that make sense, John?
Yeah, I think it does. Especially when it's said like that.
Your signature is a device for obtaining money, property, or labor, or services, correct? And if the lending of that name is an extension of credit, then it was done on credit, right?
Yep, right.
Anybody that thinks otherwise, again, the link is down there. Please hit the like, share, and subscribe button. Hit that StreamYard link and come on up and discuss it with me. Because I don't like sounding like an idiot. I don't like being wrong. And if you have a different position on this, a different definition, a different way, a different thought, a different concept, please come explain it to me. I am open-minded. I will listen. I do not want to sound like a babbling idiot. I do not think I sound like a babbling idiot. But if you think I do and can point it out to me, please do so. I don't want to be misleading others.
You're no babbling idiot.
I hope not. I hope not. You know, I claim other people are babbling, and I shouldn't really do that so much as I do, and I'm working on it. Because again, folks, I used to babble. I used to be the bitch ass slave. I used to be the fucking fool. I used to be the idiot. I'm not ashamed of having to eat that. None of us are perfect. Josh Junio coming up with a clip clip this shit as I read it, folks, because this is a great statement. Love you, brother Josh Jonio. I believe the signature is the intellectual property that needs to be given to the fund. And that's to fund or animate their corporation. And understand, corpse is not dead body. It means body. So when we think about corporation, it's the body oration. It's how your body speaks. This is your actions speak louder than words. Are they verbal? Are they oral? Are they literal? I believe the signature is the intellectual property that needs to be given to the fund so as to animate their corporation. Signature guarantee. My signature alone guarantees it. Why do you need something else? Medallion stamp signature guarantee is a medallion stamp signature guarantee is from a bank who is guaranteeing they have personally identified the accommodation party and is willing to sign on their behalf as the surety guarantor. And why would they do that? Is it because you extended credit to them in a private contract, allowing them as the broker to deal with all of your future brokerage instruments? The next one. This is 12 CFR 1026.1. Authority, purpose, coverage, organization, enforcement, and liability. This is an important part to understand about them third-party debt collectors and the fact that you signed on that instrument, therefore you lent the credit. Authority, this part known as Regulation Z, is issued by the Bureau of Consumer Financial Protection to implement. Again, remember that 48 CFR 52.212-5, contract terms and conditions required to implement statutes or executive orders hyphen commercial items, commercial services. In other words, this is an implementation between the Bureau of Consumer Financial Protection and the banks, the Federal Reserve. This is one of their contract terms and conditions. This part, known as Regulation Z, is issued by the Bureau of Consumer Financial Protection to implement. That means it's a contract term or condition. The Federal Truth in Lending Act, which is contained in Title I of the Consumer Credit Protection Act, as amended 15 U.S.C. 1601. This is 12 CFR 1026.1 that covers 15 U.S. Code 1602, the definitions, wherein when we go to previous 15 U.S.C. 1601, congressional findings and declaration of purpose, and you'll be amazed to find out my people are destroyed for lack of knowledge because they are not informed use of credit. Congress finds that economic stabilization would be enhanced and the competing among the various financial institutions and other firms. Remember that document I show everybody from the court where they transferred or converted the last name to a firm name?
With the obligor numbers.
Yeah. Firms engaged in the extension of consumer credit. So they took my name as an extension of consumer credit for their court registry investment system and invested it in their name by pooling my firm name along with all the other people that were victims in that court that day. They're using your credit. engaged in the extension of consumer credit would be strengthened by the informed use of credit. Folks, I am doing my best to inform you of your use of credit now. But again, like I said, don't believe me. Don't believe the neighbor. Don't believe these government fucks. Don't believe mom and dad. They're probably idiots. And I'm not talking about yours. I am specifically talking about mine. And I have no problem calling them idiots because they're the ones that stood there and told me, Keith, the police are your authority. And when I had aught with that, my dad looked at me and said, fuck you. So I urged him to come walking back out the door after he turned around and ran his ass inside. 6'4", 300 pounds. Bring it. You think the police are my authority after you raised me up to believe in this Holy Spirit? Sounds like you're the one indoctrinated and needs a little better training, but I can't do anything about it. You're set in your ways, you old fucker. And excuse me if it seems like I hate them. I don't. I hate the things they say and do, but I love them deeply in my heart. They did a lot for me in my life as a child. That helps me understand what's going on now. Had they done a better job, I might be a better person. Had any one of those parents in my life done what they needed to do to teach me instead of sending me off to somebody else believing they were going to teach me when they weren't taught themselves in that same system. Getting ridiculous, folks. We as a class of people, a society as a whole, en masse, are becoming dumber and dumber. Dumberer and dumberer. I'm just doing my job. I'm tired of listening to it. It's sickening. It is so redundant. I'm just doing my job. You're just doing your job and complaining that you can't help me because you're just doing your job, and that's the way it's done. And I'm telling you, no, it's not the way it's supposed to be done. It says otherwise here. And I'm telling you, folks, across the board, you sign that name on any document, that is what is lending credence to that document, no matter what kind of instrumentality it is. Without that name, that document has no effect, let alone any force or enforcement. It's blank. So let's get back to it.
We should ask our parents how it was done in the 1700s or the 1800s.
Yeah. Well, and see, there's a lot of stuff we can't have access to anymore, but I urge people to go back through the old newspapers. Look back through the old newspapers and look at the language that they use and see how it's changed. And you will find out in those changes, it has become more and more ambiguous. They keep adding more and new terms. More and more of them. Where if you learn how to go back to the simplicities and stick with the norm, you're going to find yourself a lot better. Contract is, in fact, a contest. So I contest the record. I contest the record as this man portrays that I owe the debt when in fact it's the accommodated party that owes the payment, and I extended credit so he could make that payment. Why haven't you done your job and done the ledgering according to? Oh no, just do my job. No, your job is to do the double entry ledgering. And just because you haven't done it that way doesn't mean that's not the way it's supposed to be done. Authority, this part known as Regulation Z. Make sure I'm on the right page here. Yes. Is issued by the Bureau of Consumer Financial Protection to implement the Federal Truth in Lending Act, which is contained in Title I of the Consumer Credit Protection Act as amended 15 U.S.C. 1601. This part also implements Title VII, Section 1204 of the Competitive Equality Banking Act of 1987. Furthermore, this part implements certain provisions of the Real Estate Settlement Procedures Act, as amended 12 U.S.C. 2601. In addition, this part implements certain provisions of Financial Institutions, Reform, Recovery, and Enforcement Act, as amended 12 U.S.C. 3331, et sequential. The Bureau's information collection requirements contained in this part have been approved by the Office of Management and Budget under the provisions of 44 U.S.C. 3501 and have been assigned to OMB number 3170-0015, Truth in Lending. Purpose. So twice now we have the purpose as the informed use of credit. Why are we not being informed? You would think that if it's a purpose to inform the people of their use of credit, that they would do so. What do you think, John? Sorry about the ears there.
No, it's just a crying shame that not only do we not know about our credit, they're using it against us.
Absolutely. To your detriment. I have a hard time explaining this stuff to my companion. And she used to be a special education teacher. I thought she had an intellect. But again, I'm telling you, I'm a pretty intelligent guy myself. I like to think so. And I'm not trying to make my head big or anything. But I'll be damned if I'm not still kicking my motherfucking ass. So again, I used to be that bitch-ass slave. I used to be that idiot. I used to be that fucking fool. I'm urging you. Again, don't believe me, but at least listen to me so you can contemplate the ideas I'm putting forth. And then do your research. Don't believe me. Don't believe the neighbor. Don't believe the government, for crying out loud. Do not believe your mom or dad. Do your research so you know. Let's get on to the next one. We're going back to 15 U.S. Code. Oh, we already did that one. Let's go to that 44 U.S. Code that they just mentioned. 3501. Purposes. Man, don't they like to tell you about the purpose. And I want to show you again. Purpose. Minimize the paperwork burden for individuals. So when I was walking out of jail and I had that discharge document from the court judge, and then the lady on the other side of the counter wanted to tell me I had to sign the release paperwork. I had to give them that signature. I said, no, thanks. Well, we can't let you out unless you do. Oh, really? You're going to violate the judge's discharge order? See, I'm not the one violating it, folks. She would be the one violating it. She would be the one not letting me out, despite the fact that her boss told her to let me out. Well, this is the way we've always done it. I don't give a fuck. Just because everybody else walked in here not knowing doesn't mean I don't know. I'm just doing my job. I don't care. Your job is to know better than I do. Yet you don't. I guarantee you even the mayor of this town doesn't know better than I do. And again, it's not because my head is swelling. It's simply because I have a certain knowledge of certain facts that I know for a fact most people do not know. Because it wasn't taught to us. None of us were taught about the informed use of credit. Had we been taught about the informed use of credit, we'd have been knowing the accommodation party. We'd been knowing about the address. We'd been knowing about who to send it to and hand it over to a proper broker and say, hey, I'm the accommodation party. Do your job. That's the release, or that's the minimalization of the paperwork. You have somebody else that is in fact qualified and does know their job and will do their job. For individuals, small businesses, educational and nonprofit institutions, federal contractors, state, local, and tribal governments, and other persons resulting. Here's that collection. Remember we talked about payment and collection earlier? Resulting from the collection of information by or for the federal government. I'm telling you, folks, that is the initial problem when we enter into all these documents. We start entering data elements. It's an error in entry. Greetings, NPC. Appreciate it. Appreciate it. I do my best. And again, like I said, I hope people are listening, but I'm telling you, do not believe me. Do not believe the neighbor. Do not believe the government. For crying out loud, don't believe your mom and dads. Do your research so you know. Thanks again, brother. Hit that like, share, and subscribe button, folks. There's a PayPal link down there for anybody that wants to share any love. All is appreciated. I don't care if it's $5, $500. I'm always appreciative. It all helps. Do what you want. And in the meantime, StreamYard link is down there for anybody who wants to join us. We are going to end up here shortly. Just got a couple more to go. But what do you got on it so far, John? You got anything you want to speak out on?
Well, I mean, so much for the Paperwork Reduction Act. I mean, they fucked that up.
You know, that's one of the things I was thinking about too, because again, when you look at these terms and conditions as a matter of implementing these statutes and executive orders as contracts, as public contracts, you get to see that. When you start comprehending, you get to see that it is in fact what they're doing is they're passing their job onto you because they don't know their job, even though they confess or profess that they are just doing their job. In fact, all they're doing is collecting a paycheck to take home and provide for their family, and they don't give a fuck about nothing else. Hitler's willing executioners. They are willing to do what their boss tells them, regardless of any other consequences, so long as they get a check for doing so, and their boss will give them a pat on the back and say, that's okay, we'll take care of it for you. Don't let them worry. Don't worry about that. We'll take care of it for you. We got you covered. You're insured. We got a surety bond that'll take care of it. Just more paperwork, isn't it? So let's take a look at the next one as we're talking about those public contracts. A contract is an agreement between parties creating mutual obligations that are enforceable by law. So don't sit there and tell me I'm obligated without accepting your own obligation. The basic elements required for the agreement to be legally enforceable contract are mutual assent. 1. Expressed by a valid offer and acceptance. 2. Adequate consideration, not benefit, consideration. 3. Capacity of the authorized representative giving an unambiguous signature by authorized representative. 4. Accommodation. And legality, the points that are required. So you have 4 points that are required, and of those 4 points, the legality is the totality of those other 4 points. In some states, elements of consideration can be satisfied by a valid substitute. So the equal consideration in the purchase of an automobile is the valid substitution of the automobile itself for your own use. Not as a remedy, not as a benefit, but as a valid substitution for the consideration that you can't get back. Possible remedies for breach of contract include general damages, consequential damages, reliance damages, and specific performance. They should all include specific performance as a matter of correcting the records to its integrity. The record must reflect accurately, and so far the double entry ledgering hasn't been done accurately, and as a matter of specific performance, I require the records to be corrected. If in the record it shows that there were damages of any sort, consequential, reliance, or general, those too must be taken care of. Outside of that, as this is only possible remedies, there is actually harm and injury to myself. I would require full compensation for those as well. That is the reimbursement of the credits that were not accepted and instead demanded from my own wallet. What do you think, John? Does that seem a reasonable remedy to be reimbursed as the law says?
Sounds a lot more reasonable to me.
I don't know about you guys. But I firmly believe that those credits are still sitting there, and all I got to do is make the valid claim. That's what I'm working on. Holding everybody else up to their obligation of specific performance. That's it. You were paid to do a job. You didn't do the job completely. I'm just requiring the completion of the job pursuant to contract law. Pursuant to contract law. Recognize that one, John?
Oh, yeah. That's a biggie.
There's that implied covenant. Remember, we were talking about that indemnification, right? Implied covenant of good faith and fair dealings. The implied covenant of good faith and fair dealings in your public officials is that they know this and they should be abiding the law, and that when you pointed out that they're not and that they haven't fulfilled specific requirements, specific performance, they should get off their ass and fucking do it now, because they have a responsibility and obligation in equal consideration to fucking listen to me, that First Amendment expression that I've been explaining. See, my people are destroyed for lack of knowledge. So if I have knowledge I need to express, I singularly have a right to express that exponentially. If I can get 10 people to sit down and listen to me while I teach them how to fish, I didn't just teach 10 people how to fish. I taught 10 people how to fish that will then carry on that teaching to others exponentially. In that freedom of speech, that expression, and other people's right to know. When I express an error to one of the public officials that has a specific performance, they're not to say, well, I'm just doing my job. They're supposed to fucking listen. Otherwise, they break the implied covenant of good faith and fair dealings. And like I said, the cocksucker that's going to sit there and say, I'm just doing my job, he's taking a paycheck home because he's got a family to take care of, and he don't give a shit about nothing else, let alone the implied covenant of good faith and fair dealings. He doesn't give one fuck about you. That's what needs to change. Tired. I am so tired of Hitler's willing executioners. That's why I wear this. It's a constant reminder. Let me pull it up. Let me pull me up. Excuse me here, John. That's why I wear this. It's a constant reminder to you, the public officials, and most certainly myself. I don't want to be a Hitler. I don't want to be a Hitler's willing executioners. And if you don't like the concept of Hitler and the Nazis and all the atrocities that are going on, and you think this is my reminder to you, damn well it is. Implied covenant of good faith and fair dealing, often simplified to good faith, is a rule used by most courts in the United States that requires every party in a contract to implement the agreement as intended. As intended. It is intended that when somebody gives a signature, it is a lending of the credit, not using means to undercut the purpose of the transaction. The rule applies in the performance of a contract, not to the negotiation of the contract, and to the rules, and the rule applies to generally any contract automatically without being stated in the agreement. It goes on to say, the rule is infamously hard to pin down as courts repeatedly alter its application and meaning because good faith and fair dealing depend heavily on the context of the agreement. Therefore, I'm going to ask you specifically, Johnny, because you're the one up here with me, but I'm asking everybody. I want you to think about this question. Therefore, would it not be wise, rather than letting it ride as an implication, as John mentioned earlier, shouldn't it be specifically mentioned? That way there is specific performance. Just like the accommodation party, for accommodation by authorized representative should be specifically stated so that specific performance can be had as according to the specific capacity. Is that agreed, John? I mean, did I make sense there? You agree with that?
Yeah, it made perfect sense.
Hallelujah, praise God. Everything I do, every breath of life I take is an act of God. So every pen stroke I make through that breath is in fact an act of God. Good faith and fair dealing should go in there, and I should make that known first. That way the presumption that I'm acting in person is not taken as a presumption, and therefore they would know that I am the living soul signing and handing over credit to the person. I hope everybody understood that. And if you don't, just rewind and re-listen. Go back and unlearn what you've learned and relearn concise English, and you might comprehend it someday. Again, I can explain it to you, but I cannot comprehend it for you. I am not the person, neither are you. You are not the resident, nor the United States citizen, neither are you. Those are all impossibilities. You cannot be two things, just like you cannot serve two masters. You cannot serve the Father in heaven and the false patriarch. Typically, courts find that a party breaches this rule when they act in ways that obviously undermine the benefits to the other party from the contract, or if one party attempts to sabotage another in performing their end of the agreement. Listen, I have an obligation to my signature. And that obligation is make you understand, no matter who fucking taught you nothing, that I'm the one that's extending the credit, not the bank. The bank has use of my credit because I am the accommodation party that signed the instrument, lending the name to the account. For example, if a famous athlete signs an agreement only allowing one company to use their image on products in exchange for a part of the profits, a court would likely find that the company must attempt to make and sell those products, even if the contract did not explicitly say as much. This is because the athlete only makes profit if products are sold, which naturally implies the company makes and sells them. So if I make an agreement knowing that the lending of my name is the extension of credit, that's specific performance. They have to accept the fact that I just gave them credit and that now they have to figure out how to make that payment through the person because that's where the credits sit. And if you demand those credits as payment from me through a different type of payment and those credits are still sitting there, I demand, as pursuant by law's requirement, to be reimbursed as the accommodation party, because whether I sign blank or with a unambiguous signature, it doesn't matter. I am presumed to be the accommodation party, and after the fact of the liability, I now need to be reimbursed. Simple as that. Does that make sense to you, John?
To me, it does. I hope it hits more people, though.
I hope so too. But it's sad, you know. I know you do your research. This man comes to me with stuff and shows me stuff I haven't seen. And I'm grateful for it. That's what we need more of on this panel. Like I said, I don't want to sit up here being big-headed and sound belligerent or sound like I'm babbling or think that I'm right all the time. I hope I'm right, and I believe sincerely, deeply that I am right. But if anybody finds that I'm babbling, that I don't know what I'm talking about because they know better or something, hit the link, come up, and let's discuss it because I need to know so that I'm not going out there teaching people how to fish and then they can't fish because I taught them wrong. Like I said, we recently had a success in arbitration in regards to a purchase order for an automobile. And we hope to be able to refine it and repeat it. This is not a one-off. This is the way the system is supposed to work. And when people can learn that and comprehend how to do that and repeat it, we will be that wealthy nation because we do have a set of people that understand how this owe no man anything but to love one another. For to love one another is to fulfill the law. And if that's the thing that's emanating from America, the United States, then we will, in fact, be, not just be known as the greatest country on the earth, but we will, in fact, be the greatest country in the world. And that is dependent upon the people, you. Again, I don't see how this nation can be so wonderful if its population is stupid. And again, I used to be stupid. I used to be one of those idiots. I didn't know about the informed use of credit, but now that I do and I'm learning more, it's becoming more and more effective. Oops, we just lost John. And like I said, I hope to be able to show step by step one day, and hopefully it'll be soon. Like I said, these are classes that I do every Saturday morning, and it is slowly built, and we don't allow too many people into it because it does take a certain level of discernment, comprehension, and diligence, and we don't let people just come in and take notes. You have to be involved. You have to do your research. It doesn't mean just sitting there taking notes and hoping something will work for you someday. You have to be involved. So again, it's been going on for almost 4 years, and there's still only 30 people in it. Started out with just 3 of us. But through this group of people, hopefully I'll now be able to bring forward step-by-step details that we, again, as a group can put out and start showing people and educating people how it works. But again, you can't just sit back. You have to be involved. You have to be able to know how to use the words in arbitration. So think about this stuff, folks. I want to thank everybody. Joseph Ra, Dr. D. Head, Joshua Gionio, the Tribe, of course, Bear Jew, NPC the Game. Go check out NPC the Game. Great channel over there. Go check out the Tribe. He does a lot of stuff on jurisprudence and how the law works in these courts and everything. Go check him out. Got Bear Jew and Fuzzy 75 says car number plates. Here in Australia, they run that credit card every time they scan that number plate through the system. Yes, a credit card is any card, plate, coupon, or device, credit device used to obtain money, property, labor, or services on credit. So that license plate on the back of the car that says you're a resident under a public contract to drive for the state, the governor, at the pleasure of the governor, doing state business. They have to have access to the credit side. You don't know that because you were never informed of the use. And of course, what do we have highlighted down here? Joseph Ross says, but non-citizens are getting deported. To where, Trump? Yeah, non-citizens. That's part of the problem is people using these identifications without knowing the diplomatic level that they should be at. And that's what this truly is all about, is diplomacy, learning how to address each other in the proper capacity, not as the debtor, but as the creditor. Flesh and blood, we are creditors, and the debtor is the person, not yourself. You're supposed to love each other. And it's the implication that you believe another man owes you a debt that shows that you don't owe him. You don't love him. Excuse me. Yes. So I do need to start with a grammar class. Sounds about right. Yes. You've been duped into believing that this English language is so perfect for you, yet they use a different grammar style in all the different jurisdictions. Like I said, they keep making it more and more ambiguous by coming up with more and more new terms to use. So we have to understand that grammar is the indoctrination. You have to learn it and understand what they're using. And this is Isaiah 54:17. I want to make sure I've got it perfect right here, word for word according to the King James Version, and somehow I'm slipping here. No tongue shall prosper against you. Ye shall rise up against every tongue that places judgment against you. This is the inheritance of the servants of the Lord, and their righteousness is of me. So if you've got to rise up against all the tongues, then that tells me you have to learn those tongues. And the way I see this is that, like I said, the different jurisdictions use different words. Yet again, in the UCC 1-103 rules of construction, it tells us in subsection 3 that the law is construed to be uniform throughout all jurisdictions. And I'm telling you, the law doesn't start at the bottom. It starts at the top with the Word of God. That's where the credence comes from. And it's supposed to go through you into the documentation. Owe no man anything. Use credit, not debt. The credence is the truth. And the truth has to sit in the words, not the numbers. Think about this stuff, folks. And remember, I love you, but I don't give a rat's ass whether you love me back or not. That's to say, I don't care if you hate me. I don't care if you don't respect me. That part is on you. So may God bless you. And have a good night. In the meantime, again, hit that like, share, and subscribe button. There is a PayPal button down there for anybody who wants to share some love. If you think this is valuable for you, throw a little kindness my way. In the meantime, we'll see you next time. Bye now.